Council meeting of February 7th, 2023. Time is 6 p.m. Opening prayer, Jamie.
Right. Let's rise. Heavenly Father, we come to you today asking for your guidance, wisdom, and support as we begin this meeting. Help us engage in meaningful discussion. Allow us to grow closer as a group and nurture the bonds of this community. Thank you. Amen.
Pledge allegiance to the flag of the United States of America and to the republic which stands one nation under God, indivisible, with liberty and justice for all.
Would you please call the roll?
Member Stroya?
Here.
Member McLeister?
Here.
Member Matheny?
Here.
Member Wyrick?
Here.
Member Revolt?
Here.
Member Warren?
Here.
6 present.
Motion to excuse member Orr. Second.
All in favor?
Aye.
Opposed? Motion carries. Okay. Moving on to recognition of the public. At this time, people wishing to address City Council may do so. Each speaker will be given 5 minutes. Comments will be limited to legislative items appearing on tonight's agenda only. The rules for speaking will appear on both screens as well as the time. This will serve as the only warning for everyone in attendance. Any violation of the rules will result in ejection from the premises. Anyone wishing to address tonight, please approach the.
Chuck Osborne, 307 Fairview Street, Southeast North Canton, Ohio. On tonight's agenda are 2 resolutions to again place before the voters of North Canton 2 property tax levies. I'm speaking to Resolution 19, 2023, a road levy, Resolution 2023, a sewer levy. The City of North Canton has utilized property tax levies for decades to provide needed revenue to fund city services. Clearly, North Canton's artificially low income tax rate of 1.5% is inadequate. This is quite evident as North Canton has for many years gone to property owners in the city and asked them to ante up additional tax dollars through numerous property tax levies. It is time for City Hall to stop going to the voters for added revenue. For one thing, it is a financially risky revenue stream. Voters can always say no. There is an added risk that has come about at this time that none of us had envisioned. That is submission of ballot language that was unacceptable by the Board of Elections for placement on the ballot. Wouldn't it be much simpler to be honest with the citizens and eliminate repeated property tax levies and set an income tax rate that meets the city's needs? Thank you.
Anyone else wishing to address council? Okay, moving on to new business. Kind of a motion and a second to suspend Council Rule 23 to allow for consideration of resolutions 19, 2023 and 2023 without a committee report. Revolt moves.
Second.
All in favor?
Aye.
Opposed? Motion carries. Ben, would you please read the title of Resolution 19-2023?
A resolution for the submission of the question of a replacement and increased tax levy for the purpose of providing for the general construction, reconstruction, resurfacing, and repair of streets, roads, and bridges under ORC sections 5705.19G and 5705.191 in the city of North Canton, Stark County, Ohio.
Stephanie.
We have talked about this before. Is there anything additional that you'd like to say?
Yeah,
Or
I think we need to have a discussion as to why we're here.
Yep.
And so we have the law director with us, and we do have reason to make a couple of technical corrections to these 2 resolutions. These corrections were brought to our attention on Friday, late afternoon, by the Stark County Prosecutor's Office. And the prosecutor's representative indicated that they felt that the way we had it worded in certain spots were going to put them in a position where they were going to deny us access to the ballot. So we should note that the notice to us was done at such a time in which there was no possibility for a cure prior to the decision. So my recollection that these matters were filed with the Stark County Board of Elections on January 24th. And it wasn't until February 3rd that we were apprised of any issues with our ballot language. Now, issues are a matter of opinion by a very qualified attorney in the prosecutor's office. There are no issues with the staff in doing their job. But this language was prepared also by our attorneys, and we feel that the language that we submitted initially is language that should be allowed to move forward to the voters. Differing opinions that require the opinion of another attorney that wears a black robe to make a decision, because this is an opinion. It is not etched in stone. So when we talk about, I think some of the Wayne jump in at any time, and you will, I'm sure, after I quit blathering on. But you know, in the, I guess I would call it the preamble to the actual ballot language that was in the ordinance, the preamble, you know, used a couple words, additional, and the prosecutor's office felt the word should be increased. It has no bearing on the ballot language. It has no bearing on the decision that the voters would make. It's an opinion that it should be this word instead of the other. It's not a statutory requirement. It should be this word or the other. It's an opinion that it should be that word. Well, that shouldn't, if that's, you know, the sole reason, in this case it isn't, but it adds to a list of reasons. So part of what we're doing tonight is going ahead, okay, well, we'll make that change. It'd have been nice to know this earlier. And I think at the end of the day, I guess I get to the end of the story here. At the end of the day, and I think I mentioned this to Robert last night, is it's not about us versus them. It's not about North Canton versus the world. It's not an R or a D issue, a conservative or liberal or anything like that. It's about public service. How can we say that the system works, that there's justice, when you're advised that there is a problem and there is no time to cure it? That makes no sense to me. So that is unacceptable, that there is not a cure. We know that the issues that go to the ballot ultimately have to go to the prosecutor's office for this kind of valuable work. And we know that items are supposed to be submitted to the Board of Elections 90 days, no later than 90 days before the election in which they're to appear on that ballot. And we're not saying that that needs to be changed. We think that there's, you know, at the end of the day, regardless of which side, you know, carries the day, at the end of the day, the solution should be, it's really a policy matter, a procedural matter that the prosecutor's office could implement, that would say, hey, listen, if you want your language reviewed by us in the prosecutor's office, please submit it to us 150 days prior to the election, or maybe it's 180 days before election, whatever number it is that they feel comfortable with, that they can turn it around. And then we will look at it. We will get back to the political subdivision with our comments, if any, and we will do that in such a time frame that allows you, if there is a change that is required, that will allow the political subdivision to make a correction, an amendment, if you will, and still be able to file it with the Board of Elections 90 days prior to the election if it's required. This is not rocket science. That's that's really what, and if it's us in this case that brings this to the light, that we can make this administrative change, policy change it's not changing the law, it's just changing the procedure. If they can do that, this, we think will be a service to all of the political subdivisions in Stark County. In the future, should anything ever arise with ballot languages. Keep in mind that it's attorneys that write it and that there can be differing opinions on how it goes. So that's ultimately what I hope comes out of this. That it's not, we're trying to, anybody's trying to get one up on some other political entity. That's not what this is about. So another one of the matters that was a minor technical was identifying a proper subsection of a section that needed to be in the language. So that was 5705.191. And, in layman's terms, I shouldn't say layman's terms, to just the guy on the street trying to explain it to him, we were citing the whole section. We had the egg. And the prosecutor with the subsection is saying, I'm talking about the yolk. Well, the yolk's in the egg. It's all in there. But understand that, respect that if that's what you want, if that's what we need to do, that's part of the correction that we would have here tonight. And we hope that we're able to get that, those questions answered that you might have and get both of these passed so that we can get that along on the next level. And at the end of it all, when we're done here tonight with 6A and 6B, we're going to ask council for a voice vote on a authorizing the law director to proceed with any and all legal means necessary to secure placement of our matters on the ballot. So that's kind of where we're heading. Two of the other items that have arisen out of this, there's an interpretation that there's a specific time frame in which you can replace a levy, and that generally it's done in less than 12 months remaining on the existing levy. But there are two exceptions to that. And, in preparation of our ordinances that we brought forward, we believe we meet those exceptions. Exceptions can be interpreted differently. The prosecutor's office is interpreting it a little different than what we were. There is concerns raised about whether or not, one of those exceptions under public assistance that roads and storm levies, storm sewer issues are a matter of what we would consider public assistance. Great. Well, there seems to be some difference of opinion on that. What does the Ohio Revised Code say? What is the definition of public assistance? Not defined. Not defined. It's subject to interpretation. What does it mean? It means different things to different people. To some people, it means fire and EMS. Fire and EMS, then maybe it means more than that. Maybe it means storm sewers. So that kind of lays out, some of the issues. A couple of those we can't resolve here, but the ones that we can resolve here have to deal with the word additional and have to deal with subsection 5705.191. Is that fair? Is that good?
It was a fair summary, clarification first, and in relation to the additional versus increased language. I would agree that while the word additional appeared in the, a good way to describe it, note that the ballot language that would go to the voter ultimately included the word increase. If the ballot language was copied directly from the Ohio Revised Code, so it meets the requirements within the Ohio Revised Code. To clarify a timeline issue, just so that the council understands kind of what we're dealing with here timeline wise, is we did have everything filed as of January 24th. 90 days prior to the election would have been February 1st. We received the phone call and email from the prosecutor's office on February 3rd. So we had a 7-day period from the time we filed until the deadline. We did not hear from the prosecutor until 2 days after the deadline. Additional time.
Is it typical that ballot language is thrown out like this?
Well, I don't know if I don't know that we can say that. We certainly don't know what happens in every county,
Right.
in 88 counties in Ohio, what everybody else is doing. But there are instances where things don't move forward, on the ballot, and there's instances where there's mistakes made and they do move forward, and the people have to live with the consequences. You may recall the Hartville or Uniontown police levy, and there was the issue of a decimal point being in the wrong place. It made a difference as to how much money was raised. It was an error, it was a mistake, but the judge ruled that was going to go forward, and that's what they would have to live with.
Yeah.
So, but again, in a situation, that probably wouldn't have been one, in all fairness to the prosecutor's office, that they might have caught, because how do they know how much money they want to raise? But as far as, pulling language from the Ohio Revised Code on whether something meets the language requirements, or in this case, the prosecutor's office thinks that this may be an area in which they have a different interpretation, then that's what the legal system is set up for, is to determine what is that.
But isn't so much of it a standard form? I mean, I don't imagine that our director of law was reinventing this whole process. I mean, much of it had to have been very standard. So like you said, you followed the revised code, you had the word additional in there.
Well, so the ballot language is pulled directly from the Ohio Revised Code as far as what you have to submit for the ballot language. The preamble leading up to it, explaining what the process was, what the city needs, what they're desiring to do, that's not standard.
Exactly.
That's language that needs to be filled in.
Mhm.
It's almost
Anything
like,
that can be pulled from the Ohio Revised
Okay.
Code, we do. We pull
Okay.
it directly from the code, place it directly in, so there's
Okay.
no issue with that.
so let me ask you this, is there always that beginning portion? Or if we had just put forth just the ballot information from the Ohio Revised Code, is that acceptable? Or is there always a introduction portion?
You have to have the introduction portion because you have to cite specific provisions of the Ohio Revised Code that apply to whatever you're bringing. So if you're bringing, an educational levy, that has its own subsection. If
Okay.
you're bringing fire EMS, that has its own subsection. So that language is always going to be unique for each levy. The only thing that I would say is standard would be the language that has to be
Yes.
presented to the voters on the ballot.
Yes, okay. I'm sorry, one question. Did we engage with them any in December? Was there any back and forth in December about the language they wanted, or not really?
That we were never given any indication that there was a problem with our language.
Okay.
And, we do know that, I think it was last year, there was some communication with the Board of Elections. I think we had sought pre-review of some ballot language, and we received an email from them that we don't do pre-reviews. So,
So you could never have submitted to them the beginning portion and said, hey, what do you think about this? Let's meet your standard. I just want to make sure we're all good up until that point. Correct?
Yeah.
Interesting.
I don't know if this is a fair question, Wayne. So we're talking about matter of semantics as far as it goes, as far as a word goes. But as far as like the different subsections being listed or not being listed, is this the same level of attention to detail, or I guess that might be a bad way of putting it, that cities are held to in other counties? I mean, do we see this? And maybe you can't answer that, but I don't know. It just seems interesting because, like Patrick said, we're talking about the egg. They want us to specifically talk about the yolk, but the yolk is in the egg.
That is a tough question. I'm not sure that I can answer that with a complete answer. What I'll say is that, the prosecutors in each county go through this review for any county, any any submission that happens in relation to the revised code. And each prosecutor's office is gonna have a somewhat different standard that they hold themselves to as far as what
Okay.
needs to be in and whatnot. There's not a uniform aspect of it. The way that it was described to me, with an election law, it's kind of quirky, kind of wonky in that there's certain things that require strict compliance, and there's certain things where basically if you have, you know, the meat and potatoes of it, that it's acceptable. And as far as the application of those items, I think that is gonna be somewhat subjective on a county by county basis.
Okay.
Depending on who the person is reviewing it.
Okay, interesting. Thanks.
Well, and this isn't the first time that we've brought anything to the voters, so we know how to do this. And so it's frustrating that this is the process.
Yeah, for sure.
And is there a suggestion, like, sorry, just put it on next time? That's it.
No, there is no solution in their mind. Their solution is,
Sorry.
you're out, too bad, go to the voters another time. And, you know, we all are, you know, sensitive to, you know, what we ask the voters. We certainly don't do it willy-nilly. It's well thought out what we're asking for, and we're doing it in the context of, you know, what else is being asked of our community.
Right.
And, you know, we know that the school intends to be on the ballot in November with an ask for the middle school, small ask. And they made their case to the public, you know, a couple weeks ago, when we had a meeting here. And we think that that's being fair. It's giving everybody an opportunity, and it's not all dumped on them at one time. So it's not just, you can just go put it someplace else.
Right.
So I think as we look at the need for more roads to be paved, specifically at the sewer issues, in light of problems we've had, things that need to be addressed, Wayne, do you see any availability in terms of relief of getting this resolved on the May ballot, or are we working for something for the future?
That depends on the interaction from the other side, quite frankly, to an extent. There are methods by which we can petition to have this on the ballot that would go beyond just approaching the Stark County Board of Elections. They call it mandamus action, where you basically appeal to the courts and say, in essence, we disagree with the findings of the Board of Elections. We ask that you mandate them to put it on the ballot. And in that situation, it's an expedited hearing, it's an expedited appeal because of the timeliness of the matter. And so ultimately, in the event that that mandamus action would be successful, if the city chooses to file it, then it would likely appear on the May ballot.
I think Patrick has rather diplomatically described the current process. That process is terribly flawed, but it is the process that is in place today. And it is in the context of that current process that we will be making decisions. David, I want to step back to the comment you just made and point out that this is not necessarily, while it is I guess, an intellectual argument between the use of additional and increase and a whole section versus a subsection. The fact of the matter is that constituents derive value, however we get there, to repairing streets and maintaining sewers. We have real issues on the storm sewer side that we want to address. We know that we have streets that need repair, and we are falling behind with each passing winter in their maintenance. This is a real issue.
And to go back to a comment I made the other night, which is the fact of the matter is that streets do, the maintenance of streets, bring value to those homeowners. It helps their property values. Patrick's point, now, yes, we do make a calculated judgment about when to place something on a ballot. We want to avoid the noise of other campaigns, whether they be national or whether they be other ballot issues for funds, because we want the voters to focus on that issue. To Mr. Osborne's point, is this the way to do it or do we do it some other way? But the point is, we choose this for a reason. I'm troubled by this. And I'll make no bones about it. My blood is warm. The fact of the matter is, these issues were submitted timely to the Board of Elections. There were 5 working days in this flawed system to review 2 documents, which are not complex. This is not quantum physics. The prosecutor, the board and the prosecutor sat on that for 5 days, working days. And then called and rejected it. No opportunity for cure. This is not a model of public service to that person who's up on the northwest end of town who has a sewer issue that we're trying to address, the person who needs their road repaved. This isn't helping them. 5 days, no action. So, oh, sorry, we can't help you. I beg to defer, but if the prosecutor only learns today that his deputy has rejected this, there's something wrong in that office. There's something terribly wrong. And again, this isn't about the council. This is about that person up in the northwest corner of North Canton who needs sewer assistance. I think what's even more troubling is that there was no effort, none, made to find a workaround. None. Tough. Fiat. Boy, that is a great model for public service here in Stark County. Very disappointing. Not going to affect me. Not going to affect any of you other 6 or the administration. But that family up in the northwest corner of North Canton, yeah. Not interested in a cure. Not interested in work. No suggestion of how we might partner to get this on the ballot. None. That is a horrible indictment of that office. You're looking for a vote on mandamus? There's one.
Yeah. Here too.
We need to give the voters an opportunity to decide this, one way or another, up or down.
And that's who should be deciding it.
And that's who should be deciding. Not someone who can't fix this in 5 days or even look at it.
2-page document.
Yeah.
And I think the bottom line is this doesn't even affect the language that the voters see. So it's
Absolutely
not even,
not.
yeah. So
That's the key point.
Yep.
This is an intellectual, academic argument. As Mr. Diorio said, it's an opinion. Okay, what's at stake? Are we deceiving the voters? No. Are we fooling them? No. It's right there in the ballot language. But the time, if he had reservations, was when it came into the office. give us a call for cure. Didn't happen.
Which the cure, we would have done in 2 minutes.
Mm-hmm.
Yeah, we would have fixed it.
2 words.
The
We
only
needed something else.
thing I'll say, I mean, you can't look at this policy and tell me it's not broken and that it serves the people. It doesn't. The policy needs to change, you know. That's, I'm very very upset. So,
All right.
Well, I can tell you this, on a lighter note, this is all wrapped up. It's not wrapped up successfully. I'm going to have a contest to name the worst paved street in North Canton after this winter, after Kyle Stone. All right, so all the voters know. Thank you, Prosecutor Stone, for your assistance in maintaining our streets.
Okay.
What do you need?
yeah.
Was it already read?
Yeah, we
Read the title, yeah.
You just need a motion to adopt.
kind of a motion and a second to adopt the first reading of resolution 19-2023.
So moved.
Second.
All in favor?
Aye.
Opposed? Motion carries. Can I have a motion and a second to suspend the rules of council requiring 3 readings?
So moved.
Second?
All in favor?
Aye.
Aye.
Opposed? Motion carries. And can I have a motion and a second to adopt resolution 19-2023 under suspension of the rules?
So moved.
Second.
All in favor?
Aye.
Opposed? Motion carries. Okay, Ben, would you please retitle the title of resolution 20-2023?
A resolution for the submission of the question of a replacement and increased tax levy for the purpose of providing for flood defense, providing and maintaining a flood wall or pumps, and other stormwater improvement purposes to prevent floods in said city under ORC sections 5705.190 and 5705.191 in the city of North Canton, Stark County, Ohio.
Okay. We just talked about, I think, both of them together. Are there any other corrections to this that you wanted to go over? But again, just focusing on the citizens, and that's what it's for. Okay, if there are no other issues, I move to adopt.
Second.
All in favor?
Aye.
Opposed? Motion carries. Can I have a motion and a second to suspend the rules of city council requiring 3 readings?
So, second.
All in favor?
Aye.
Opposed? Motion carries. And can I have a motion and a second to adopt resolution 20-2023 under suspension of the rules?
So moved.
Second.
All in favor?
Aye.
Opposed? Motion carries. And we don't have department reports. Are there any other new business or any other?
So
comments?
I would like to
Right.
seek a voice vote on to authorize the director of law to seek any and all means necessary to secure, an attempt to secure these 2 issues for a primary ballot. So I'd like to authorize it to be able to move forward.
Okay. Ben, could you do a roll of voice vote?
You need a motion first.
So moved. Or no, I guess, not that easy, okay. Do we want to write it out?
I will move that the council authorize the administration and through the Department of Law to pursue any and all means, legal means, to place these 2 items on the
Second.
All in favor?
Aye.
That's-
Or was it voice vote?
Voice vote.
You can do roll call if you want.
I think you wanted a voice
All
vote, right?
Roll call. Member Revolt. Tally here. Member Shroya.
Yes.
Member Warren.
Yes.
Member McLeister.
Yes.
Member Wyrick.
Yes.
Member Matheny.
Yes.
6 in favor, 0 opposed, 1 absent. Motion carried.
Thank you. Any other comments, discussion?
I think it's important that we get it on the ballot. The citizens need to make a decision in May, and if they choose not to support the ballot issue, then we have our course set for us to resolve the issues.
Right.
Yep.
And if we have to wait a year to get that answer, I don't think we're doing a favor to any of the citizens in North Canton.
Agreed.
Agreed.
It's a large portion of our budget.
Mm-hmm.
Okay. I'll make a motion that we adjourn.
So move.
Second.
All in favor?
Aye.
Opposed? Motion carries.